All right, we're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, Counsels Love and Hilton. Okay, Counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right. Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God or so affirm?
Yes, I do.
All right, you put your hand down, sir. All right. Mr. Sledge, over the next several minutes, what's going to happen is we're going to go through such a thing called the providency inquiry. So basically, in our system of jurisprudence, we don't force people to plead guilty. So I have to be assured you understand your constitutional rights and that you freely and voluntarily waive those rights so I can go ahead and sentence you. The second thing it does is we go through a factual basis, and I determine if there's a factual basis that the state would have been able to prove in this case beyond a reasonable doubt had they tried the case. So assuming that I find that you understand your rights, we call it the Boykin inquiry, and then the second thing is then I find that there's a factual basis I can accept your plea. So Ms. Ladies, which one of you is going to do the plea?
I am, Your Honor.
All right. Ms. Love is going to go and ask you a series of questions in just a minute. And then your attorney, Mr. Wright, will follow up with that. And then I'll ask you a couple of questions, and I should be able to sentence you in accordance with the negotiated plea, okay?
Yes, sir.
Okay. All right. Ms. Love, whenever you're ready, madam.
Thank you, Judge. Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Mounk Tounk, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes, ma'am.
as listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that the minimum sentence for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act is 5 years and the maximum is 20 years in prison?
Yes, ma'am.
Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 1611-133, is 15 years in prison.
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today, but that the state is not recommending either?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea involves your being placed on probation, and that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence? Do you understand that?
Yes, ma'am.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice given to you by your attorney or anyone else?
Yes, ma'am.
Do you understand that if at any time you are sentenced to confinement based on this sentence, neither the court, your attorney, nor the district attorney's office has anything to do with parole, and that in that circumstance, the Department of Corrections or Board of Pardons and Paroles
Yes, ma'am.
are the only persons who can address parole, and that no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your right or ability to obtain employment. Do you understand that these rights may be affected?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of another felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself.
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up all of these rights?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement, the state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in Section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within Section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 1, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demikion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 10, defendant has personal knowledge that on January 10, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. Number 11, defendant did not murder Donovan Thomas Jr. and was not a party to the crime. Number 12, defendant did not murder Shamel Drinks and was not a party to the crime. Number 13, defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of the murder, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
Through. Changes to E. And then initial right there.
And Mr. Sledge, is that your initial above the strike through of the word began to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you signed your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence State's Exhibit 1AS.
No.
Any objection? States 1AS is admitted for purposes of plea.
Mr. Sledge, how do you plead to count to the charge of conspiracy to violate the Racketeer Influence and Corrupt Organizations Act as alleged in count 1 of indictment 22 SC 183572?
Guilty.
And how do you plead to count 30 of this indictment 22 SC 183572, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yeah, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file what is known as a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, the state will now provide a factual basis for this plea.
All right, go ahead, ma'am, whenever you're
Your
ready.
Honor, if this case were to go to trial, the state believes that the evidence will prove beyond a reasonable doubt against this defendant that the defendant, together with indicted and unindicted co-conspirators in Fulton County, on or between January the 24th, 2013 and May 8th of 2022, did unlawfully conspire to acquire, maintain directly and indirectly an interest in and control of United States money and other personal property through a pattern of racketeering activity. Furthermore, defendant did unlawfully conspire to conduct and participate in directly and indirectly such enterprise through a pattern of racketeering activity. The enterprise, Your Honor, as described in this indictment and as the state expects the evidence will show, is called Young Slime Life, also known as YSL. And during the time listed in the indictment, the defendant, along with others, conspired to associate together and with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in this enterprise through a pattern of racketeering activity. The objectives of the conspiracy included, but were not limited to, protecting, preserving, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, obtaining money, weapons, and other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. Your Honor, YSL is an enterprise consisting of a group of individuals associated in fact. It constitutes an ongoing organization whose associates function as a continuing unit for the common purpose of achieving its objectives. YSL is a criminal street gang that started in late 2012 in the Cleveland Avenue of Atlanta, Georgia. Their identifiers vary, and they use common identifiers including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers, Your Honor. Your Honor, in furtherance of the conspiracy and to effect its objects and purposes, this defendant committed overt acts which reflect his tacit agreement to participate in the enterprise through a pattern of racketeering activity. Those overt acts include but are not limited to the defendant's possession of cocaine with the intent to distribute as alleged in Act 8 of Count 1 on November the 29th of 2013. The defendant's commission of the aggravated assault as listed in defendant's factual acknowledgement on April the 28th of 2015. The defendant's commission of Act 45 in count 1 on April the 28th of 2015, possession of a firearm by a convicted felon. The defendant's commission of Act 46, as alleged in count 1 of the indictment on April the 28th of 2015, of participation in criminal street gang activity. The defendant's posing while an associate of YSL for a photo released on social media wearing pants with the letters OTS, standing for Only the Slime, with the caption of OGs with the green snake emoji and green heart emoji on April the 8th of 2021, as alleged in Act 128 of count 1 of this indictment. And Act 151 of count 1 on December 5th, 2021, as alleged in count 1 of this indictment, wherein defendant possessed a firearm while previously convicted of a felony involving the use or the possession of a firearm. Your Honor, as the defendant acknowledged in State's Exhibit 1AS, defendant has been associated with YSL since 2012 and has committed the acts that are contained in this plea agreement as well, which also reflect defendant's tacit agreement to participate in this enterprise through a pattern of racketeering activity. Your Honor, the defendant, as I stated earlier, has pled guilty to the commission of acts along with other YSL associates in furtherance of the gang YSL. Specifically, Your Honor, beginning back in January of 2015, after the murder of Donovan Thomas Jr. in Fulton County, a series of retaliatory shootings between YSL and the organization of which Mr. Thomas was a member began to occur. One of the retaliatory shootings is the one that is listed in defendant's factual acknowledgments in State's Exhibit 1AS. Your Honor, as recently as this year, earlier this year, the murder of yet another person whom the organization considered a rival, Mr. Shamel Drinks, took place, turning 2022 into sort of a repeat of 2015. Your Honor, the defendant has knowingly, voluntarily, and willingly signed this plea agreement, and as a result of the defendant's willingness to be forthcoming and to be truthful and to own responsibility for his actions, the state is willing to make the recommendation that I've relayed to the court, and we ask that the court accept this negotiated plea agreement. Your Honor, that is all that the state has. If the court will permit me one moment, please.
Okay.
That is all that I have, Judge. Again, we would just ask that the court sentence the defendant to 15 years of probation on count 1. As to count 2, we would ask that the court withhold sentencing until after the completion of the initial trial of this case, and that after the initial trial of this case, provided that the defendant has complied with the special conditions outlined and contained in the plea agreement, Your Honor, the state agrees that the defendant shall be allowed to withdraw that guilty plea on count 30, and the state shall agree and will agree to no loss on count 30. Your Honor, further,
Mr. Wright is well. He's Mr. Sledge in the sentence already. Is this going to release him?
Your Honor, he that closed out once you did the time.
Yeah.
Judge, the case that was referenced that he pled guilty to before for the ag assault is closed. So he's not currently under an active sentence.
The issue is gonna be is that he's got no sentence under that particular count 30. So I'm not gonna have to give him bond. I mean, I
I
can.
made bond
The
already.
sentencing on count 30. He won't be able to release it.
Initially, when he was arrested for count 30, he was given a $31,000 bond that he made. So
So that bond still remains in.
that bond is still in effect for that, I guess, underlying charge.
As of right now,
But
in this case, there's no bond set. We don't know if that was the previous indictment, but as of this case, 22 SC 183572, possession of a firearm by a convicted felon, no bond.
Your Honor, if I may, the state has no objection to the court granting a signature bond as to that count, subject to any restrictions that the court feels necessary to place on the defendant, and considering the fact that the defendant has now pled guilty to that charge.
Restrictions that should not be in. This is a delicate and delicate disposition. Normally, we do not hold over these counts, but for the clerk's office reasons, we have to fashion it this way. You can only do count 1 and then count 30 as a bond. That is the only way you can do it. So he's really accustomed. If you don't either they can give him probation on that count, and then once he completes all the conditions, they can come back and do an order, not crossing back the count. So before the state does any type of this, they need to check with the clerk's office to see what is the criteria that needs to be met before the passion of these type of distribution. Because I was told, once I made the phone call, he will not get out of this chamber. He will not get out. Either off of probation or not cross it down and press him on the back end. The conditions, they can always come back. But try to get out. So,
Your Honor, will the court permit the state a moment to confer with Mr. Wright and to ensure that we...
Sure. You got one of several, you got one of a couple options. You just can't do it this way.
Yes, Your Honor.
I'll recess it.
Thank you, Your Honor. Mr. Wright, may I see?